First of all, I convey my gratitude to Vidhi Utsav to invite me to deliver this keynote address. I see Justice Rajiv Shakdar. I extend my very good morning to him and to all students who are assembled here. Courtcraft was a subject that was requested to me by the organizers, and I believe that I'm in my 40th year of practice, so maybe I can share some insights with you on this subject, which cannot be practically taught in law schools. It is something which is to be acquired by being in the court, in the physical space or the mental space. Then only this courtcraft can be acquired as a skill. So I have prepared a note for it, and I have given it a title, Rainbow of Courtcraft. A rainbow radiates 7 colors, so does the courtcraft. So the 7 colors which are there in the courtcraft according to me, and this is not exhaustive, there may be many more facets. First is, don't miss forest for the trees. Preparation with understanding of larger perspective of the problem. 2. Rome was not built in a day. Patience to listen to the judge and to the opponent. 3. Silence is golden. Art of knowing what not to speak and when not to speak. 4. If gold starts rusting, what will iron do? Practice the highest degree of courtroom etiquette, if not for anything else, for your own branding. Advocacy is not a rat race, because even if you win the race, you remain a rat. Shun the tendency to have the last word. 6. Keep it simple like haiku. Demystify and decode the complex propositions. 7. Akal ke saudagar, merchants of wisdom, who use psychology and anticipation as working tools. So I begin with a quote, and that's the only quote I am going to use. The quote is that of Thomas Grant QC. Like conversation or theater, the essence of advocacy is the impression it makes at the moment it is given voice to the immediate audience to whom it is made. The words itself and the meaning it is intended to convey is only half the efforts. Put fine in words in the mouth of a poor advocate, and those words can die on the tongue, whereas the great advocate can conjure magic out of the proverbial laundry list. So this quote is very reflective. This quote indicates that how you articulate the proposition in the court is extremely critical, because the best of content that you may have may fail to achieve the desired result if it is not presented in a proper manner. Now the first point that I indicated to you is don't miss forest for the trees. This pertains to the preparation. The first lesson which is taught by our seniors when we join the profession is that we must master the facts and study the brief in detail. The lesson is important because if we read the file carefully, we would succeed in filtering out the trivial details, secondary arguments, which may be needed only in the backup plan and in the set process, the main focal points which need to be addressed as the principal submissions can be identified. This is the most important lesson. However, in the initial stages, most of the junior lawyers, for want of experience, carry out the drill of reading the file, clouded with either the client's perception or their own perception, and miss the focal point. As a result, even after reading the whole file, the desired objective is not achieved. The trivial details are perceived as important, while the central issue, which needs to be identified, is missed. It is a situation akin to missing the forests for the tree. Oftentimes, one may forget that a legal problem may be multidimensional, having several facets to it, and such as social, political, emotional, financial, as well as practical aspects. Therefore, it is important to look into any case from every possible angle. Now, I give an example. A matrimonial dispute usually involves, apart from the justification for seeking divorce, the questions of division of joint assets, maintenance, permanent alimony, custody, and visitation rights in relation to children. If such a dispute is to be resolved or any favorable order is to be secured, it is important for a lawyer to be able to ascertain as to what is the primary concern of her client and what is the bottom line, which would define the satisfaction of the client. So here you see there are three aspects. You need to ascertain from your client that what does she or he want, and thereafter you have to structure your strategy accordingly. So reading further, in such a situation, if the lawyer allows herself to be clouded by the perception of the client rather than the relief which the client seeks, the desired result will not be achieved. So the point that I am making is that you please ascertain from your client what is the relief that he or she is looking for. Not be swayed by the perception that he or she is holding in her mind, because that may be one-sided, that may be too emotional, and you may not be able to logically and rationally demystify it in the court. Reading further, it is in this backdrop that a lawyer will have to disregard the trees which represent secondary issues and keep her focus on the forest, which is the relief that she wants to secure for her client. The preparation and arguments will have to be tailored accordingly. Now the next one is 7 swaras and 21 shrutis. Listen to the judge and to the opponent. Now I have given the allegory of the music. Yeah, those of you who are fond of music would appreciate that music has 7 swaras and 21 shrutis. So I am inspired by that, I am giving this aspect. Indian classical music is based on 7 swaras and 21 shrutis. Each swara has its own unique melody and stirs an emotional feeling, which needs to be heard in order to be absorbed. Similarly, while appearing in court, be it the queries of the judge or the submissions of the opponent, they need to be heard in order to be absorbed. Just by listening to the judge's question, you can realize there is another dimension in the matter which did not occur to me, and maybe thinking on my feet, I can explain or attempt an answer. Alternatively, if I don't have the answer, I can at least assure the court that I will revert on the question in the course of the submissions, thus managing a breathing space to satisfy the query emerging from the bench. So this is a very important aspect of the courtcraft, because if you think that court is a place where you can have a monologue, or that whatever you have prepared, you are going to dish it out and just be satisfied with that, It doesn't happen like this. Court is a very highly interactive place where you need to be in constant interaction, uh, both of spoken words and more than that of unspoken words, which you have to understand from body language, etc. Now, coming to the second point in this, similarly, just by listening carefully to the opponent, I may realize certain merit in the argument of the opposite side, and to deal with the same, I can make appropriate preparation by the time my turn comes. Needless to say that listening is an art which has to be mastered with the virtue of patience, humility, and alacrity. If I am arrogant, I am likely to be full of myself, and therefore automatically I am unlikely to be finding any virtue in what others speak. Therefore, the first step towards the craft of listening is developing a temperament of humility, modesty, and quest for knowledge. Now, this requires an acceptance that whatever knowledge I possess till now is just a drop in the ocean. Patience is equally important, for if I am patient, I am more likely to focus on the interaction between the judge and the opponent making an impact with an argument, and making my case wither away. And in such situations, if I am patient and able to absorb what I am listening, I may have the use for another virtue of a lawyer, that is alacrity, and I can react quickly in dealing with a dynamic situation arising in the court with greater control, instead of just interjecting time and again to derail the proceedings. This I am warning you that this, whenever you go for the court hearings, you see lawyers interjecting. This interjection is an expression of exasperation and some sort of discomfort that they are feeling. So it is for to each his own. I mean, all of you have to adopt your own style of arguments, but please keep in mind that this is not the most preferred working tool for a lawyer. You should always try to avoid it and adopt a better and more dignified tool, which is more effective. Patience teaches us that it is important to wait for our turn, our time, and our eureka moment. It will surely come at a predestined time, whether it is a case or it is a career as a whole. After all, Rome was not built in a day. To sum up, we need to keep our eyes and ears open, lend an ear to whatever is being spoken in our surroundings, and find music in it. So that sums up the second one. Now the third is silence is golden. Art of knowing what not to speak and when not to speak. Nothing strengthens authority so much as silence. This is what Da Vinci said, and inspired from that, I take it forward. Three of the most essential tools that should be in every lawyer's toolbox are silence, active listening, and critical thinking. Here, let us focus on the virtue of silence. In my professional career over a period of time, I have learnt that silence is not only golden, it has its own sound. I learnt it in the court, noticing that after making the best point, which would have secured the relief for a client, a lawyer kept on arguing and ended up diluting the impact of the best point that he made. The relief eluded the lawyer. Lesson number 1 in the chapter of silence is to know when not to speak anymore and take your seat. You can know the moment by the body language of the judge, body language of the opponent, or by your own instinct. Now, these are the things which are integral part of your overall upbringing, your overall style that you practice as a lifestyle, and it doesn't come one fine morning. It has to be acquired over the years, and the instinct is something which is very natural and personal to each of you. Instinct will help you in making an assessment of when to stop. If you have prepared well, prioritized your points, and covered all relevant aspects of the matter in your submissions, if you fail to take advantage of silence, you might lose out on two critical advantages. First, you miss the opportunity to observe the valuable verbal and non verbal leaks that silence inevitably forces your opponent to make. Second, you obliterate the ability to seize upon the risk adversity the greater majority of people possess. In order to make it easy for your instinct to help you in such situations, it is important to follow a particular sequence of submissions which makes you first present the facts in a coherent manner, state the law that applies, and conclude the submissions at a note which is your best point. I prefer to call the sequence as an inverse pyramid. See, the inverse pyramid is like this. Once you scale down to the tip of the inverse pyramid, your instinct will tell you to take your seat. So, first of all, in the inverse pyramid, you lay the foundation, which is broad, and then you have to, by method of elimination and filtration, ultimately reach to the conclusion that you wish to present before the court. Equally important for the court craft is to know as to what will not be appreciated by the court, either as a submission or as an interjection or as an illustration or as an observation which is not called for, which is not contextual, which is not in good taste, which may be offensive to the environment of the court, or which may unnecessarily waste the time of the court. The key is to avoid creating anticlimax. Situations when silence is the way to go. When the court is inclined in your favor, it is extremely annoying for the court that the counsel, by elongating the arguments, is preventing the court from proceeding further, either to hear the opponent or to pick up the matter next in the list. Silence as a technique is equally applicable to the cross-examination. If the answer given by the witness has achieved your purpose, further cross-examination could be fatal and may amount to undoing of all the good work which you may have done till that point. Any unnecessary question on a topic which should be closed by us pursuant to the favorable answer will reopen the room for the witness to explain the inconsistency or self-damaging component of the answer given by him. It has also been seen that sometimes in a cross-examination, the counsel is giving a suggestion to the witness which is contrary to the case of the client. To illustrate the point, the plaintiff wants to establish that the defendant used its trademark in a gathering held by him at the defendant's place, conveying an impression as if the gathering is held or is sponsored by the plaintiff. And for the said purpose, it produces a witness stating that he had also attended the gathering so held by the defendant. The counsel for the defendant is not supposed to suggest to the plaintiff's witness that there were about 50 people attending the said gathering. Irrespective of whichever way the question is answered, an irretrievable damage has already occurred by a suggestion that a gathering was held by the defendant attended by about 50 people. So the purpose is defeated. Now the next is, if gold starts rusting, what will iron do? All of us in our young age, when we join the profession, we have a dream, and the dream is that we will reach a point in our career when we will be evaluated on a gold standard of the highest standard or the highest standards of the profession. And this evaluation can be in many aspects, not just on the touchstone of how much of money you have earned, but on various other aspects. So the tagline is explained as follows: practice the highest degree of courtroom etiquette, if not for anything else, for your own branding. So forget that if by not maintaining the etiquette, you have annoyed somebody, etc. But you must be at least, everybody wants to preserve one's own interest. In that sense, there is nothing wrong in this. Ayn Rand has written a whole lot of literature on this, and it is always a subject matter of intrigue that if you put Ayn Rand's literature vis-a-vis Karl Marx, then it will make a very interesting comparison. So there is a virtue of selfishness, there is nothing wrong. So at least for your own branding, you follow it. I am of the firm belief that the courtroom etiquettes are the lifeline of the legal profession. The seniors have a legacy not by the amount of money that they have earned or by the number of cases that they won. The legacy lies in leaving a robust value system for the next generation of lawyers. It is the value system of a particular bar which defines the character of a bar, the strength and caliber of its members, and promotes which promotes the justice delivery system by the courts as the most preferred alternative of dispute resolution. Therefore, in my view, the value system must be akin to gold standard. It is equally important that in criminal courts, where the atmosphere is otherwise stressed, the people assemble in a situation which is anything but happy, a polite and humane value system encompassing compassion for the litigants, victims, family members of the victims who appear in the court as the consumers of the justice delivery system. The behavior of the seniors towards the junior bar, without exception, must be that of welcome, guidance, encouragement, politeness, patronization, and protection. Correspondingly, the behavior of the juniors towards the senior members of the bar must be that of courtesy and respect. Success brings many vices, and one of them is arrogance. The arrogance, when practiced as an integral part of advocacy, results in disservice to the clients because sooner or later it will start impacting the level of preparation, standard of presentation, and eventually the results. If success in the profession is equated with a lawyer having won the gold medal, and then as a gold medalist, the general behavior, conduct, and attitude becomes toxic, it would certainly be the beginning of erosion of the brand which the lawyer concerned has built. Therefore, if the gold starts rusting, what will iron do? I have no doubt in my mind that this part of advocacy is an indispensable part of the courtcraft. One must remember that after the game of chess is over, king and pawn are packed in the same box. Advocacy is not a rat race. Most of us think it is. It is not. Because even if you win the race, ultimately you remain a rat because you were participating in a rat race. So, the byline is shun the tendency to have the last word, because this will take care of lot many issues which will bug your courtcraft. Because it looks like it's very fascinating, it looks very glamorous that I had a last word. What is more important, having a last word or having a last laugh? So obviously, so if the answer is clear, shun this tendency. So, and this tendency arises from this mindset that I have to win the race come what may. True advocacy is not about outperforming others or securing victory, but it is to work in the ecosystem of courts and assist the courts as its officer in securing justice for the client. In my view, the courtcraft needs to be structured around the basic objective of advocacy. Inevitably, as one grows as a lawyer and achieves success, legendary rivalries are formed. Bar loves it, and youngsters look up to the duels between the two rivals, the top lawyers, with great deal of anticipation in the process. They gain by acquiring many tools of courtcraft, which may not be so easily discernible in the matters which are routinely argued with much lesser intensity. The key question is whether the royals should transform their rivalry to a level where both of them would like to belittle the other at personal level and would want to have the last word at every occasion. This question is intricately linked to a growing perception that aggression is an essential tool of advocacy. I have no particular opinion about the style of advocacy, categorized as aggressive, moderate, soft, or hybrid in any combination. It is a personal choice. However, the problem arises when aggression is misunderstood as a tool of intensity. This is where the problem lies. What is expected from a lawyer is that she would argue the case with intensity. Intensity, which means the quality of being felt strongly, which can be achieved without being aggressive. On the other hand, aggression is described in dictionary as a spoken or physical behavior that is threatening. The courtcraft lies in understanding this nuance. In pursuit of aggression, best of lawyers may end up losing the focus or end up committing a mistake. Contradistinguished, intensity can be maintained without losing cool by maintaining a good temperament in the course of arguments. It is possible for a lawyer to maintain equanimity, which reduces the chances of inflicting self injury in making oral submissions. In my understanding of courtcraft, it is important that the submissions in the court need to be made in the spirit of a healthy debate. It is not the lawyers who are in competition before the court. Rather, it is the case of the rival parties with competing interests which is there before the court to be adjudicated. Therefore, there is no need to play to the gallery or making attempts to score a point of one-upmanship for the sake of optics. High-stake matters are akin to cricket test matches, where it is often prudent to play the last ball of the day without scoring a run. Making a closing submission is one thing, and trying to have a last word in every sequence of submissions is another. The latter is not needed. Take, for example, a situation where an argument is inconclusive in the matter and the matter is likely to be adjourned for another day. In my view, in such a situation, prudence lies in not disclosing or initiating a critical point of the argument, knowing well that you would not be able to take it to its logical conclusion on that day. By doing so, you would give an opportunity to the opponent to extensively prepare a counter argument. The surprise element will be lost. So when you know the matter is getting adjourned, hold your horses. To conclude, shun the tendency to be in rat race, for even if you win, you remain a rat. In the next one, I have taken inspiration from haiku, which is a Japanese style of poetry. Keep it simple like haiku. Demystify and decode the complex propositions. At the outset, let me demystify haiku. It is a form of poetry popular in Japan, extensively followed in India, known for short and unrhymed poems. Ordinarily, it consists of 3 lines. Succinctly put, it epitomizes conveying the sentiments of the poet with simplicity and lucidity. The globalization of trade and commerce, multiplicity of business models, advent of technology and artificial intelligence has led to new concepts such as cryptocurrency, non-fungible tokens entering the commercial ecosystem. These are just examples. There is a huge list. Some of it Mr. Anand has touched in his address. Resultantly, the face of litigation has completely changed. It is multi-layered, multifaceted and complex, having traversed beyond the traditional typification of civil, criminal and tax. When we started, these were the three broad categories. But now, to enlist the litigation in these three broad categories will be a disservice to the profession itself. Today, the legal profession has thrown open the doors for a variety of new subjects such as money laundering, mergers and acquisitions, combinations, anti-competitive agreements, security and exchange board regime of, and then the regime of GenCos, TransCos and DISCOMs in power sector, public-private partnership in infrastructure, personality rights, moral rights, plant variety, geographical indications, production sharing contracts, etc. The list is long. Now, if the disputes occur, the litigation in many a niche area is bound to be complex, and inevitably the lawyer needs to acquire the domain expertise. Juxtaposed, the judiciary is expected to adjudicate all types of matters that may arise in the overarching umbrella of dispute resolution regime. In such a vast field of legal subjects, the likelihood of a judge being mystified in appreciating the nuance of a matter brought before her cannot be ruled out. The above emerging trends have posed a challenge to the legal fraternity to acquire the requisite courtcraft to explain subjects which are seemingly complex and are laced with fair degree of unfamiliarity for other stakeholders of the justice delivery system. The challenge in this regard can be met only by acquiring the necessary skills of being able to decode the subtle nuances of a complex subject and demystify the element of unfamiliarity. The time is ripe for the legal fraternity to inculcate this skill as an integral part of the courtcraft. After all, a haiku is as enjoyable as an epic. Now, Akal ke Saudagar, that is merchants of wisdom who use psychology and anticipation as working tools. Now, this is a little heavier than the narrative that I have given till now, but this is extremely important, highly critical for a lawyer to acquire as a working tool for his courtcraft or her courtcraft. All stakeholders in a justice delivery system are human beings. Most importantly, the judge. For a lawyer, each layer of human beings involved in the entire ecosystem is a challenge, because at each stage, a lawyer is required to understand the psychology of the person and anticipate a particular level of response, be it the client, the opposite party, the opposite lawyer, the witness, and above all, the judge. A good lawyer is expected to know the psychology of the judge and accordingly tailor the legal strategy for presentation of the case of the client. The upbringing, the surroundings, the education, the belief system, the value system, and the financial background of a judge are some of the factors which will definitely combine to tilt the balancing scale in the matter of decisions taken by the judge. The scale of justice in that sense is seldom straight. Faced with such a challenge, while framing the oral submission, it is an integral part of the courtcraft that a lawyer should remain cognitive, conscious, and considerate about the above factors which shape a judge. Equally important is to know as to how the mind of the rival lawyer is functioning on the same parameters. At the same time, the lawyers cannot undermine the thinking process and the expectation of our clients. Needless to say that such a knack or a skill cannot be acquired overnight, and a good deal of experience blended with fair degree of understanding of psychology and the flair for anticipation would make it possible. While there could be divergent views as regards the answer to the question, when and where did the legal profession originated, yet there cannot be any conflict on the highest respect accorded by the society to the legal practitioners. They may have been the merchants of wisdom or Akal ke Saudagar, for they make their living by making use of their brain and wisdom. Come to think of it, We as lawyers, we don't have any commodities to sell. What we sell is our intellect, which is directly related to our mind. So it is in that sense we are akal ka saudagar. So we have to use our brain, intellect and discretion very discreetly and very judiciously and in a very important and balanced manner. So therefore, to sum up, a good lawyer therefore uses psychology and anticipation, because you have to anticipate at every moment what is likely to happen in the journey of a particular case, because just like I have a journey in my life, every case, every proposition, every brief has a journey of its own, or maybe a horoscope of its own. So therefore, it's very important to understand that aspect. So therefore, I am ending this aspect by saying that this quality is a complete code in itself and constitutes 9 points of courtcraft. Just like the adage which says, possession is 9 points of law. Possess this skill and walk to the top. Thank you very much.